I'm David Craig with the law firm of Craig, Kelley Faultless. Today we're talking about comparative fault. What is comparative fault? Well, comparative fault is when you compare the fault of everybody that's involved in a wreck. And the fault has to add up to 100%. So let's say there's 4 cars that are involved in the wreck. You would look at the fault of all the 4 cars and you determine what percentage of fault each one of them is. In Indiana, you can still recover for the damages as long as you're not more than 50%. And if you're 50%, then you still win. So let's say there's 2 vehicles and both of them are 50-50. Then the person who's injured can still recover against the other party for up to 50% of their damages. So if they have $100,000 worth of damages, then they're entitled to $50,000. On the other hand, let's say that you're 0% at fault and the other driver is 100% at fault and you have $100,000 worth of damages. Then you would recover 100%, so you would recover $100,000. However, if you're 51% at fault, then you don't get to recover for any of the damages. Now, who decides what percentage of fault you are? A jury ultimately decides. And the jury then decides what fault is the defendant and what fault, if any, is the plaintiff. When you hire a lawyer, the lawyer, what they do is try to preserve and protect the evidence to show that you're 0% at fault or very little at fault, but that the other people involved are either completely at fault or they share the majority of the fault. If you or someone in your family have been seriously injured, or someone in your family has been killed by the carelessness of another, please feel free to give us a call at 1-800-ASK-DAVID, or you can check us out on our website at ckflaw.com.